Welcome to the Unit 4 hearing for the National We the People Invitational. My name is Ryan Susky. I'm the Director of Programs at the Ohio Center for Law-Related Education, and I'll be serving as the facilitator for today's hearing. In just a moment, I'm going to have the judges introduce themselves, followed by the students, and then we will kick off the hearing. The process for the hearing today is a 4-minute prepared statement from the students, followed by 8 minutes of follow-up questions from the judges. Now, my microphone will be muted during the hearing, but I am going to be holding up time cards for the students, so we do highly recommend that you have your computer set on gallery view so that you can see those time signals and, of course, your colleagues throughout the hearing. Once the hearing is finished, judges will give some brief feedback to the teams, and then we will conclude. So with that, I'm going to go ahead and hand things over to your chairperson to begin the introductions.
Okay, well, welcome. Good to see you again. You know the routine now. We will just introduce ourselves and have you introduce yourselves, make sure no one changed their name overnight. So my name is Joe Stewart. I teach in the political science department at Clemson University in South Carolina.
Hi, everyone. I'm Diana Owen. I'm a political science professor at Georgetown University in Washington, D.C.
Hello again, I'm Deshawn Whitaker, We the People teacher in Charles County Public Schools in Maryland.
And please introduce yourselves and your teacher.
Hello, I'm Thalia Burtis.
My name is Daniel George.
I'm Marianne Pace.
I'm KK Sabo, and our teacher is Mrs. Neal.
Okay, great. Great to see you again. I noticed that your state coordinator is sitting in also, and if there are any questions we have, we'll refer them to him, but I don't expect that there will be questions that we have to move to that. Okay, as you're no surprise, we are going to be looking at question 2 today, and so I'll read that question. It starts with a quote from the political scientist Robert Dahl. If a law has been properly passed by the lawmaking branches of a democratic government, why should judges have the power to declare it unconstitutional? Do you agree or disagree with Robert Dahl? Why? What is judicial review and why is it controversial? What has been the impact of judicial review on American society? Once the Supreme Court has decided that a law is constitutional, what power, if any, do the people have to change the Constitution? You may begin.
Nearly all men can stand adversity, but if you want to test a man's character, give him power. These words, spoken by President Lincoln, are relevant to the power of judicial review. Although controversial in every corner of the nation, judicial review is the third branch's most potent check. The way the court has exercised this check has led to both praise and criticism, such as Robert Dahl's. However, we believe that this tool is necessary to prevent abuse of power by the other branches of government and by state governments.
Judicial review is the power of the judicial branch to decide if actions and legislation of the other branches are constitutional. Judicial review over state actions exists because of the Supremacy Clause, but at the national level, it is more complex. In 1803, William Marbury, a judicial nominee of John Adams, was denied his job. Marbury went straight to the Supreme Court for relief. The court ruled that Marbury deserved his job, but couldn't bring his case to the Supreme Court as permitted in the Judiciary Act of 1789. By declaring part of the law unconstitutional, the court assumed the power of judicial review over the national government.
Judicial review has been controversial from the start. Thomas Jefferson said it violated separation of powers. More recent critics say it has led to the rise of judicial activism. This is when judges abandon the literal meaning of the Constitution and use modern values and personal opinions to determine what is right. An early example is Lochner v. New York in 1905. Joseph Lochner appealed to the Supreme Court after violating New York's Bake Shop Act, which prohibited bakers from working more than 60 hours a week. The court said the law violated the 14th Amendment's Liberty Clause. By doing so, the court substituted its judgment for the New York legislators.
Judicial review has transformed American society for better and for worse. The Dred Scott ruling and Plessy v. Ferguson are considered the court's most infamous decisions, allowing the spread of slavery and racial segregation. Since the 1950s, judicial review has been the primary tool for advancing civil rights. The Supreme Court ruled Jim Crow laws were unconstitutional in Brown v. Board of Education. overturning its own ruling in Plessy. Judicial review over presidents has rewritten history. During the Watergate era, the Supreme Court ruled that President Nixon must hand over tape recordings of phone conversations, which led to his resignation. Judicial review over state laws has been especially impactful in the area of women's and gay rights, as seen in Roe v. Wade and Lawrence v. Texas.
Once the Supreme Court decides that a law is unconstitutional, the people have the power to change the Constitution. The most obvious way is amendments. Congress can start this process, or state legislators can call for a constitutional convention. The people overturned Dred Scott with 13th and 14th Amendments, but the amendment process is not easy. In 1990, the court struck down the Flag Protection Act that had passed both House and Senate with huge margins. Congress had tried to amend the Constitution to prohibit flag desecration, but failed to reach the necessary two-thirds majority in the Senate.
People can also affect the Constitution indirectly. The Supreme Court is not supposed to respond to political protests, but justices are human and internalize the opinions of the day. Protests can encourage new laws and constitutional amendments, as with the 19th. Citizens can also challenge prior rulings in court. They can quote the Constitution as evidence, as to the plaintiffs in Brown, who used the 14th Amendment in their case against separate but equal. Although possibility is not entertained today, a revolution remains a viable yet violent option.
It is emphatically the province and duty of the judicial department to say what the law is. That statement caused a butterfly effect in our nation's history that continues to transform society. With a new presidential administration underway, the possibility of judicial activism by a generally conservative court is an intriguing hypothetical. How the court uses its power, as Lincoln warned, will be a test of its character. We have finished our disquisition and are ready for your questions.
Well, thank you. Thank you very much. Enjoyed that. I want to talk about some of the ideas that you raised. You gave us a good definition of judicial activism. Some people associate that with one particular ideology or another. Is activism associated with any particular political ideology?
I do not.
Go ahead.
I do not believe so, because activism, you said particular ideology, whether it be left or left-leaning, right-leaning, conservative, liberal, but left people will believe that when we have a conservative court, they're practicing judicial activism and vice versa. But then just activism in general can be practiced by both political parties outside of the judicial branch, whether you're an activist for abortion or an activist for, pro-life. There's a span.
And justices are supposed to be neutral. And so when they participate in judicial activism, they're not advocating for a certain political party. They're advocating and pushing for an idea that they believe in and that they believe applies to the Constitution.
So in your opening statement, you talked about Jefferson and how he said that that judicial review violates the separation of powers. Can you elaborate on that and talk a little bit about how judicial review might violate the separation of powers, even from Jefferson's perspective or your own?
It can give more power to the judicial branch, or make it seem like the judicial branch has more power because they have the ability to decide for the other branches what they think is right. The judge can.
And part of what makes the third branch, the judicial branch, also as equally powerful as the other branches is the fact that they're neutral, because the executive branch and the legislative branch can be fought over by political parties and ideologies, but the court is not supposed to be like that. And then when they do get political, that kind of takes away that idea of separation.
Okay. Do you believe that judicial review is critical to protecting the rights of the minority against the will of the majority?
I think the judicial review is extremely important for that. We've seen in rulings where Dred Scott was overturned, that was such a that's had such a long-lasting impact on society. You have cases like Lawrence v. Texas, Obergefell, Roe v. Wade. These cases are affecting minorities and changing the course of history. Will they get overturned? Possibly, but because the court strongly believes in stare decisis, it's evident that our country tends to be stuck in these ways, and it's going to stay that way for a long time.
To Daniel's point, also the court, he says, has made important decisions that last a long time, but they have also made extremely infamous decisions that also lasted a long time. And he said they overruled Dred Scott. Well, they made Dred Scott in the first place, and Plessy, Korematsu v. United States, condoning Japanese internment camps, and also Bowers v. Hardwick in '86 that said the 14th Amendment didn't protect gay Americans, and then they had to overrule their pre-set precedent to be able to give minorities those rights in the first place.
Let's say that the legislature does pass a law that we could agree on as being unconstitutional. How does the court get that? Or let's say that if there a long period of time passes, what's the process of the court actually weighing in and checking that abuse of power that you've talked about?
There would need to be a case against that particular law. And if it started at a lower level, it would have to work its way up through different appeals to the Supreme Court, and then they'd have to accept it. So I feel that it does take a lot of effort to get a case against an unconstitutional law, or a law that some people might believe unconstitutional, to the Supreme Court, because it's a long process.
There are also places, to speak to Thalia's point, like the ACLU and then NAACP, that when there were laws they didn't believe in, they went and hand-picked cases like the plaintiffs in Brown, where they got from all over the country and they handpicked those cases so that they could take their case to the Supreme Court. So that's taken consideration.
Do you think that the Supreme Court justices should be elected by the people, or that the system that we have in place now works?
I personally think that they should be elected by the people, because I feel like that would be the most democratic choice, because the people are the ones who the judge is making laws about what the people can do. So I think it's only fair that the people should be able to make the choice of who the judge is.
I think that by having the judges be handpicked by the president, this actually changes the narrative. If it was chosen by the people, then what happens is that the judges will no longer be someone who's supposed to be impartial. They're going to be people who are chosen because they have a certain ideology, because they'll support something that you believe in. And that just removes the entire factor of them being impartial in the first place.
And to speak to both Daniel and Miriam's point, if they were elected, say every 4 years, every 8 years, every 10 years, and it wasn't for life, that could also create a big flip-flop of power between different political ideologies that have the majority at the time to elect those judges. And that would cause there'd be basically no stare decisis, because they'd just be overturning constantly precedent set by the other court with the opposite political ideology.
Okay, let's explore term limits a bit further. So you mentioned that you don't think they should serve for life, or let's get everybody's opinion on that. How do you feel about the lifetime appointment?
I personally, I can see both sides, but I think the life limit is probably a con, because that means if, say, a one-party packs the court, like some argue Donald Trump did and Republicans before him with Amy Coney Barrett and others, if they pack the court, that lasts for an entire generation, and the other political party cannot get cases to the Supreme Court to go their way for an entire generation. And like Plessy and Brown v. Board, that ruined people's lives for an entire generation, and I think that should just not be okay.
I agree that the life term limit, or not really a limit, but it has both pros and cons. And I think that it was created so that the justices didn't have to have the pressure of being reelected. They knew if they were, well,
Go ahead and finish that sentence, Leon.
Well, they didn't have the pressure of knowing they had to be reelected. They didn't have to prove to the people who would be probably the people electing them that they still were championing the same values, and they'd just be able to truly think about the Constitution the way that they thought it should be thought about.
Okay, well, great. Thank you so much for the discussion. This is one where I wish we could throw Mr. Susky with his time card out and just keep talking because you did a wonderful job talking about the issues and talking about it at a very high level. You defined your terms, the clearest definition of judicial activism that I've heard, and you talked about it in a very intelligent way. You gave appropriate citations to court cases. I wish we'd had a little bit more time to talk about other ways that that people might change things. You properly categorize them as indirect and talking about protest and challenge, even all the way to revolution. Some might say insurrection these days, just to use a term that we've seen used more frequently recently. I would like to have taken some time to think about, is non-compliance with a court decision a way that we try to challenge and change things? Because I suspect that's one of the most common ways that the individual citizen deals with Supreme Court decisions that they disagree with. I also would like to have explored more with you the idea of the Supreme Court or judicial branch being supposed to be neutral, which you stated a couple of times, and yet each presidential election we hear it's important who gets elected because that will affect the nature of the judiciary. So I think we probably give lip service to the idea that it's supposed to be neutral, but we know that no, it does make a difference who is selected. Also wish we'd have more time to talk about stare decisis because we're starting to see some cases. There was an opinion in the past week or two that Justice Kavanaugh wrote where the dissenting opinion by Justice Kagan said, you're just throwing the stare decisis out. And Justice Thomas has said that he doesn't particularly believe in it. So, but the great news is you are well prepared to wrestle with these issues. You did a wonderful job today, and thank you very much for your discussion.
Yeah, I thought you did a really excellent job today. Your opening statement, you made excellent points. It was well organized. As my colleague just said, you gave a really good definition of what judicial review and judicial activism. So you were very clear with your terms. And you staked out a clear position when you said that, this is probably the most potent check that the judiciary branch has on the other institutions of government. I liked the fact that you raised Jefferson's point about the separation of powers, which opened up the door to probe that further through a question. I thought that was, really good. I like the way that you actually, put everything in historical context. And for example, when you were tracing the cases related to civil rights and talked about the 1950s and how that era of the court was able to, kind of change things in the direction of civil rights. And when you came to the point, as my colleague said, about talking about the things that the people can do, you were very realistic about the amendment process, realizing, that's an easy one. Oh, well, you can amend the Constitution. Well, not so fast. That's not easily done. And you talked of other ways, the indirect ways that, the protests and there's protests outside the Supreme Court like all the time because people want to, get their views across. And I love the statement where you said, well, the justices are human. They are, and they come with their own positions, their own, kind of, perceptions of things and even their ideological biases that they bring to the cases. So that is very relevant. I just thought you did a great job in discussing the questions and really kind of properly using a lot of the terms, demonstrating your knowledge of things like stare decisis and some other things. So I just, oh, I also really like the fact that even though you might have staked out a particular position, pro or con, you would say, well, I can see both sides and articulate that, but okay, here's where I come down on it. And that's a really sophisticated way of answering the questions and getting your argument across. So really, really great job. Thanks a lot.
Yes, I agree with everything my colleague said. I wish we had more time. You all brought up some very good points today that just beg for a longer conversation than our 8 minutes that we had. I like that you acknowledged the ACLU handpicked cases, because that is very important to trying to get these cases passed when we're talking about the minority rights. Also, I like how you discussed with the people electing the justices, how that could be a bit problematic. Just the cases against like the abuse of power, the journey you took us on in the civil rights movement, just everything was really, really fun today. And I enjoyed listening to you all. Pleasure speaking with you. And I wish you luck in this competition.
One more thing I want to say, because when my colleague mentioned the people demonstrating in front of the Supreme Court, if you haven't already, I hope you get to visit DC and go by the Supreme Court building. And when I've taken students there, we'll walk by the Supreme Court building and there will be a group of people out there demonstrating. And we walk back by sometime later and it's a different group of people. And my students will say, well, what's going on? I said, well, they're there for the case that's being heard at the time. Once the oral argument is over on that case, they leave and the next group comes in. So you get to see exactly what you've been talking about there in action. That's clear. Thank you. Wonderful conversation today.